One of the realities of my profession is that most of our professional success arises from significant personal tragedies of our clients. This case definitely was one of those. I see our job as just affecting the ending of the story. By bringing some justice that our clients deserve to the case, we get to affect their experience for the better. In this case, my client's son was killed while crossing a crosswalk. He had lost his job during the pandemic. He had been a baker for 20 years. And after he lost his job, he was holding prayer groups for his co-workers and friends to just cope with the times. On this day, as he was going to get some snacks for the prayer group he was hosting in his apartment, he got ran over while crossing the crosswalk. But he only had one person, one survivor, that could bring a lawsuit. And that was his mother, who lived in El Salvador. And she unfortunately developed dementia about 6 or 8 months after this incident. This was a fact that defense focused on from day one. Defendant hired this large, high-powered firm out of San Francisco who focused on this issue. They kept arguing that it's a small case, that damages are not warranted because my client lived in El Salvador and that she developed dementia. I didn't agree. I actually disagree. I believe in our justice system. Everyone has an equal chance to it. Everyone is equal before our justice system. It doesn't matter where you're from or where you live or what the color of your skin is. The justice is the same. Also, my client's family members, her daughters, her family kept telling me that they all believe that their mother developed the dementia from the grief of passing her beloved son. I believe them. I went on a journey of proving their belief. So I educated myself. I actually learned that there is this significant area in the medical science that talks about how significant grief can lead to development of dementia. So I didn't relent. They kept arguing, the defense kept arguing, defense kept getting more aggressive, at times even calling out the family for wanting civil remedies for this loss. Arguing that what does the mom know? She has dementia. She doesn't even know that her son is passing. And I wasn't going to accept that. As the case got closer to trial, I consulted few of my good friends who are experts in this field. And I talked to them about what I had found in the medical literature and what my understanding of it is. And they agreed with me and they encouraged me. As the case got close to trial, this high-powered defense firm hired a foremost neuropsychological expert to testify against the damages for the mother, how she cannot understand that her son has passed. And what they got is that I turned the page on them. I took his deposition for hours. And by the end of it, he agreed with me. He became my expert. He agreed about the literature that significant grief can cause dementia. He agreed with me that the medical records we have, that the testimonial records we have, point to the grief being cause of the dementia, as opposed to what he originally started in his deposition, saying that it was other biological factors. Well, he couldn't withstand scrutiny, not mine, that's for sure. By the end, he was my expert. And as the case got to the trial, a week before the trial, they called me up, they told me that they're waving a white flag and accepting our demand to settle for $26 million. This case reinforces two important lessons. One is that the lawyers have to conform to the client's story. They are there to tell the client's story. The easiest path would have been to disbelieve the client, to say that the passing of her son had nothing to do with dementia, that she was elderly, that she had other health risk factors. But the lesson is that if the client trusts the lawyer to share their truth with the lawyer has to acknowledge it, has to be grateful about it, and has to do everything that he has to do or she has to do to get to the bottom of that truth, to validate their client's truth. We are the storytellers at the end of it, where we support our story by facts. The second lesson is that it's the attorney's job to build a case. That's a job that cannot be delegated to others. It's not the case that you start a case and you just go ahead and retain a bunch of experts, pay them exuberant amounts of money, and have them drive your case. That's not how we win big cases. How we win big cases is that we are the driving force behind the case, that we educate ourselves about these difficult topics to learn and to understand. And only when we have gained a level of knowledge where we can be confident in what we are saying or what we are believing or how we are framing the case, that we go and we talk with experts, that we go and we retain these expensive experts to come help with the case. Not the other way around. It's not for the experts to educate us, because then we are out of the control of the case. And that was what happened here. I actually didn't hire any experts. I didn't retain or didn't designate any experts. The case was proceeding to trial with only one expert, the defendants. And I, through the education that I gained as a result of this case, turned that expert to mine. And that's why the defendant didn't want to take the risk of going in front of the jury. That's why they knew that the $26 million demand that I had asked of them for a foreigner, for an elderly person, was the right number. That was the justice.